Calling case number. Calling case number. Calling case number 3348910. This is Juana Candelario versus Maximo Casanova and all occupants. Can you state your name for the record?
Juana Candelario.
Okay. And can you state your name?
Edna Candelario.
And do you swear to tell the truth and nothing but the truth? And are you translating Candelario today?
Yes.
Okay. And can you state your name? Thank you. And your name?
Blanca Ortega.
Do you live in the house as well?
Oh, no, I'm just translating.
Okay. Can you raise your hand? You swear to tell the truth and nothing but the truth. All right. Well, thank you for coming with translators. It's very helpful. This is a case for non-payment of rent.
Yes.
The first case.
Yes.
We have 2 hearings. So yep, 26. Your next hearing will be June 26th.
June 26th.
If you need legal assistance, there are lawyers across the hall at 417. And in the event you all come up with an agreement today, make sure you add 14 days. So if you don't want to come back, say you have an agreement today, then you don't have to come back in 14 days if you present me with an agreement. But just make sure it accounts for the extra 14 days he would have received. But in any case, June 26th. So we'll be back June 26th. Unless a settlement before. All right. Any questions?
She wants to know, do he need to stay in the apartment until June 26th?
Well,
Because like he's not paying rent and no bills.
right, that's why we're
Yeah.
here.
Yeah, and she wants to know if he's going to be able to stay in the apartment until June 26th or. Yeah.
Supreme Court allows for 2 hearings due to COVID. So we have to set 2 hearing dates.
Okay.
So this is the first. So if you can work it out now, just understand that you would have gotten 10 days from the 26th.
Okay.
So we'll have a resolution at the next date.
Okay.
So if they have any questions, work it out now. So when the 26th comes, ready to go.
What time, Your Honor?
9:30. 9:30 a.m.
9:30 a.m.
Yes,
June
ma'am.
26th?
Yes.
Okay.
All right, that's it.
Thank you.
You're welcome.
Appreciate it.
You all have a great day.
You too, thank you.
You're welcome. As a practical matter,
Hey.
Attorney Brayley, as a practical matter, all these cases will be on the 26th. I can call, there are no plaintiff's attorneys in here, right? Good morning.
Morning, Judge.
I'll get you all out of here.
Yeah.
Is Claude Clark here? And what's your name? What is your name?
B.
Yes. What case are you, or what case are you on? Good morning.
13646 Eastwood, 116 squatters. They don't know my name, so we just put squatters.
Okay, what, you got a case number? I mean, we only have 10 cases, so I'll march down the list. By process of elimination, we're gonna find you. And counsel, what do you have this morning?
Judge, I got
You have copies?
I am, I think we just got to read one.
Okay, is Gene Reed here?
Yes, I am.
All right, let's start there. Calling case number 2334-8948. This is Gerson Seven Detroit Renaissance versus Gene Reed and all occupants. Come on, please step up to the podium.
Judge, you want me at the table or the podium?
Well, it's up to you.
Judge will bring P 83143.
All right. And you can have her at the podium. Really. Good morning. And can you state your name for the record?
Gene Reed.
All right. Good morning, Ms. Reed. Thank you for being here on Monday morning. All right. This is a complaint for non-payment of rent. This is the first of two hearings. Supreme Court allowed for two hearings in landlord-tenant procedure. It used to only be one. So the next hearing date is 14 days away, which will be June 26th. If you need legal assistance, 417 is the room that has legal aid attorneys.
Okay.
If you work something out today with her, say you all can work something out today, then just make sure that she's afforded the extra time, which would be 14 days. You get 10 days, so the minimum you should be negotiating if you work something out today is 24 days.
Okay, I want a trial.
Okay, well, you should probably go to 417 and talk to an attorney. And in any case, come back on the 26th ready to go.
All right, but they won't evict me because I called the inspector. And that's the reason they want to evict me. I have the rent. I have all of the money.
Okay, well, maybe 417, use this time wisely. Maybe you can talk to an attorney over there. Next date is June 26th at 9:30.
Thank you.
You're welcome. Is Divine Henderson here? Is Jantiel McCord? I'll call out the address too on these. All right, so let's do your two cases and then I'll just keep plugging away. Calling case number 2334-8973. This is 629 West Milwaukee Acquisitions versus Divine Henderson.
Judge will bring P 83143 for the plaintiff. And Your Honor, I think we're going to need to adjourn much for service. Thank you.
Okay, let's take a look at the file. Well, you would know, counsel. Let's, okay, so then you're not confident Divine Henderson has this, notice?
I don't believe he was served, and I don't believe our one was either.
Okay. All right, well, let's, how do we? All right, well, how much time do
Judge, 2 weeks should be sufficient.
you want to just put it on the same track?
That works.
Okay, June 26th at 9:30 a.m. And that's the address of 629 West Milwaukee Avenue, apartment 307.
Thank you, Judge.
You're welcome. So
Yes, Judge.
Will the defendant have notice? We didn't send out notice of the first hearing, that would come to you. Well, the defendant get notice from the court at second hearing?
Yes, Judge.
Okay. So yeah, try to get that served and we'll send out another notice. If you all can do it that day, great, but if not, they'll be reported. 14.
Thanks, Judge.
On case number 23348979, it's logical PM versus Gentile McCord.
Judge will repeat 83143 for himself. And Judge, we're gonna need to adjourn this one for service.
Let's go to the June 26th at 9:30 a.m. date.
All right, thank you, Judge. I'll be back at 9:30.
All right, you are welcome.
Judge, Attorney Frazier.
Okay, Attorney Frazier. Is
Yes.
Claude Clark here? Is Claude Clark? Let's find your address. You're not on Waterman, right? What street are you on? Eastwood?
Yes.
On case number 23348954. This is Shondia Enoch Waters at 13646 Eastwood Street. Good morning to both sides.
Good morning.
Good morning. And can you state your name for the record?
Shekel.
Okay, thank you, Ms. Coleman. Good morning.
Good
And,
morning, Shondia Enoch.
all right, good morning, Ms. Enoch. Ms. Enoch, are you the owner of the property at 13646 Eastwood?
Yes, I am.
Okay. Do you have any deed? Do you have a deed?
Yes, I do.
All right, could you, did you present one to the court?
No.
Okay, can you hand it to the court officer? We're gonna make a copy of it for the file. All right, I'll wait until you,
Okay.
take your time. All right, so this is a complaint to recover possession of property. She's not asking for rent, she's asking for, possession. This is the first of two hearings. Second hearing is June 26th at 9:30 a.m. As a defendant, there are legal aid attorneys that are available. And 417, if you decide to speak to one or are seeking legal assistance, I would do it now rather than wait for the next hearing day. So, do you all have any questions? All right, if something is worked out today, make sure you account for say, find some type of settlement today or work something out. Make sure that accounts for the time.
Okay, you don't have my number, I don't have her number, so.
Maybe you all can exchange numbers today.
That's fine.
Okay, yeah. So if you work something out, we're still on the record until 11. If not, I'll see you all back on the 26th. But use this time to figure it out. Any questions?
No, thank you.
Sure.
Have a good day.
All right, you all have a great day. Thank you for showing up.
Thank you.
Where'd the guy go who was here?
They came and was.
He was just sitting right there?
wasn't on the docket.
Oh, he wasn't on the docket?
No,
Oh,
so what we had to do, we told Curtis was like, he needed to call his attorney. Because it's not in the computer or it's not on our docket that he was supposed to have court today.
Sounds like you have work.
Exactly, so.
Hey, Ms. Brady. Good morning.
Good morning. How are you?
Good.
Curtis told you about attorney Fraser.
He got his date already? Okay, thank you.
No problem.
All right. So is Claude Clark here? It's 940. Claude Clark didn't come.
No, Your Honor.
Someone on the internet. What's your name, sir or ma'am?
Anita Griffin.
Anita Griffin. Kanita Griffin. Kenyatta Griffin or Kanita?
Yes. Anita.
Good morning, Ms. Griffin.
Good morning, Your Honor.
You're scheduled for 9 o'clock with Mr. Bouchard. Although we're in person right now, I'm not going to default you for being on the Zoom.
Remember, I apologize, Your Honor. I think it's McCarl, number 83515, appearing for Ms. Griffin. We had permission from the previous hearing date to have her appear virtually because she's in.
Oh, okay. All right, thank you.
Thank you, Your Honor.
You're welcome. Yep, I wasn't gonna penalize you anyway, Ms. Griffin, but you definitely have reason to appear by Zoom, so. I don't know if
Thank you,
this
Your
is
Honor.
that. You're welcome. Have you seen, do you know who's representing?
I did not. I spoke to Brother Council Ryan Bouchard over the weekend. We
Okay.
were planning on asking for a scheduling order, but I know he wants to come in and request for escrow, so I.
Okay, so we'll sit tight.
Yeah, he did good to know.
All right, Ms. Griffin, just sit tight, and we'll call your case
Okay.
when the landlord's attorney arrives. He'll be around, he's around here
Okay.
somewhere.
Okay, it's Crystal. Okay, thank you.
You're welcome. And then I'm going to place, oh no, I don't need to place you on mute. It's fine. It's quiet wherever you are too. Is Michael Little here? Oh, did you all come up with the resolution? All right, okay, let's see. Let's see if it works. If it doesn't work, legally, I'll just refer you to legal counsel so they can structure it, but you all can come back up. Recalling case number 23348954. This is Shandia Enoch versus as listed all occupants. May I have your appearances again? May I have your name? Thank you. Thank you, Ms. Coleman. All right, what was the, what were you all able to agree to?
She said she needs some time. So I asked her how much time. She said I can give her till July 30th.
Okay, and first you're agreeable to July
More than
30th?
enough time. And I would like to see the condition of the house because I don't want it.
Okay,
Yeah.
so, my smile. Okay, that's irrelevant.
You see.
I was gonna say, just provide
24
24-hour notice. So give her a day and let this not count. So if you all arrange this, you all have your numbers now?
Do it outside.
Okay, exchange telephone numbers and then just give her a heads up. She is, her stuff is in the house and, you know, however you all work it out, just work it out, but she is entitled. She can't say no, but you are entitled to 24 hours or, you know, 48 hours or whatever. So, just work that out. July 30th, that will actually work. So what we'll do, Mr. Nobles, do you have a judgment form?
I do, Judge.
I want you to, fill out the case number. We'll have our instruction board, so plaintiff, defendant. Is there any objection to leaving her as an all occupant? Okay, so you are listed as a squatter or AKA all occupant or someone who didn't have their name on the complaint. It'll work out in your benefit to maintain your status as all occupants because it won't be a judgment in your name.
That's what I.
And it wouldn't be a writ of eviction in your name. However, all occupants, which means all occupants, LeBron James, Taylor Swift, Hillary Braley.
There's nobody else there for me.
Okay, but all occupants must vacate or a written issue against all occupants. So, as long as you all understand this, these are usually $2 downstairs. Fill that out, fill this part out, and, I'll sign it, we'll put it on the record. So just, if both of you all sign the bottom, it's box, I think, 2B that provides the date. You aren't seeking rent, so, just let me know. Obviously, we have some time to hear your case. So, yeah, just flag me when you're done.
Thank you.
You're welcome. Good luck to both of you all. See, calling case number 233489999. This is Michael Little versus Jasmine Hudson. Michael Little here. Jasmine Hudson here. Parties don't appear to be present for the first hearing. However, second hearing date is June 26th at 9:30 a.m. This is case number ending in 8999. Money judgment that was pled for, no proof of service, present in the file. 8999. Plaintiff. FTA. All right. Calling case number 2334916. This is Detroit Real Estate Advisors versus Alicia Craig. Is Alicia Craig here? All right. Attorney Malafite's case. Your new court date, Attorney Malafite and Alicia Craig, your new court date is June 26th at 9:30 a.m. As for everybody at 5074 Farmbrook, your new court date is at 9:30 a.m. on June 26th. Right. Both parties present with the translators. Good morning, counsel. I used to sit a seat at the table. Plenty of space today. Got a pretty light docket. So, is Attorney Snow with y'all?
Yeah.
Okay.
You need me to dig her up?
Not really. She's here for 9:30, so I mean, she's not late. Maybe taking her time. Maybe in another room.
Could be you.
Attorney Christensen, what case are you on?
Kelly v. Brown.
at 10 o'clock.
Okay. All right. Ernest Brown?
Yes, sir. Yes, sir.
All right, sir. Okay. Thank you.
Speak of the devil.
And so. No, I was just gonna. Their attention. Nine.
Judge was just asking after you.
Mhm.
I said, don't call her because she's scheduled for 9:30, so she's probably planning on arriving sometime around 9:30. I'm sure she's having a great morning.
It's Monday.
Monday.
Leaving Reggie.
You all ready? We calling case number 2-334-8954. Trying to be an Enoch versus all occupants at 146 Eastwood Street. May I have your answers for the last time? Thank you. Thank you, Ms. Coleman. Thank you all for being here. You all were able to work something out. Today is the first of 2 hearings. Because you were able to work something out the first hearing, there's no need to come back in person for the second hearing. Second hearing was scheduled for June 26th, which gave you an additional 14 days. But I see that was accommodated for on this move-out date because the move-out date is actually June 29th, which is a Friday, which will allow you to file for a writ of eviction on July 31st. I think you all agreed to July 30th, but that's a Saturday, so I moved it to the Friday. So that would technically give you until that Monday because you couldn't apply until that Monday. So you all can work that out. But if there's a move out, make sure you don't leave the house, open to the elements, exchange keys, or coordinate some way to secure the house that you can get in, you know. Any other questions? Any questions at all? All right, this is a consent judgment, which means both parties agree, and you're both unrepresented. So, MCR, Michigan Court Rule 4.201I. I'm pointing to it because you get a copy of this. You can Google it when you get home. But it allows for parties, unrepresented parties. If you go home and say, I made the wrong decision, and you have grounds to set this aside based on the court rule, oh, I was tricked, I was pressured, there are a few categories. If you have grounds, then you can file a motion to set this aside. But other than that, you all agree it's a consent judgment. There aren't too many surprises. It's a move out date. But in the event you had to file a motion, just review MCR 4.201I. It's your right. I wanted to make sure I let you know. So you all are free to go. The clerk will give you a copy. Good luck. And this isn't all occupants judgment. So your name is preserved in a sense. And you'll still get the same effect. So thank you, parties.
Thank you.
Well, make sure you get your paperwork. They both got their copy.
Yep.
Just one less day.
Yeah.
Mm-hmm.
One less payment for parking for them. It's done. They can go check up on each other's status. You know, very well.
Exactly.
Going.
I'm actually here with legal aid, observing the process
Okay.
since the in-person interview.
You like, what's your preference?
Well, you had recommended that they go to another room, but I'm gonna be here every other Monday, so if you see me, I can just take them here. See what I'm saying?
Then we'll get a flow.
Okay.
We'll get a good.
Yeah, I mean, I know it's a work in progress.
But it's a familiar work in progress versus, Zoom being the actual outlier,
Right.
getting people, phones don't work, figuring out who we're talking to. We know nobody's here. Well, except for Ms. Griffin.
Make sure it was in the file.
My answer.
Judge, do you have something in the file for 613?
I filed an answer in affirmative defenses last week, Judge. I'm not sure if it made it. If not, I'll go down and make a copy and bring it up.
I hate that you have to make a copy because,
Probably hanging around on the second floor yet.
no, it's hanging around, maybe right here.
Aha, I'll go make a
I
copy.
may have some time, because I try to separate the judgments and stuff I need to sign versus stuff that
Sure.
needs to go in the file. And then that pile may sit because he's not gonna double back on that.
Yeah.
But, you said 615, 613?
613.
We may have time.
I'll go down.
Give it 2 seconds. Get a lot of D's.
Good.
Got a lot of trees.
Yeah.
Okay, not so good.
All right. Good. Okay, yeah, I think.
I'll go make a copy of it.
Yeah.
Your Honor, the attorney who appeared for Attorney Cox today was the woman who was here earlier with dark. I don't remember what her last name is.
I can't remember either.
I'll go first.
Great.
But she's got the, like the red hair.
Yeah, dark, British.
Like a maroonish.
also Black frame glasses. All right, she might look familiar from Zoom. but
Yeah, she's
hopefully not.
familiar. Familiar face. Anyhow, bar.
Morning, Your Honor.
Morning. So, the docket.
Until, yeah, basically.
Have you all been submitting documents in person now that you're in person?
He is.
Okay. Have there been any previous documents submitted in person that weren't related to the case that you heard in person? I'm trying to figure out whether this stack is going to get smaller because people are in person. Inevitably, it will because people are signing in person. But for the backlog that exists, I wonder if people are just bringing it in and getting it signed.
I mean, I probably would be
I think
at
so.
this point, because it's, and I think that's what Attorney Snow was just doing too, because she wasn't sure if her thing had ended up in the file,
Yeah, exactly. That's exactly what she did.
so,
So I think you answered the question, but
yeah.
I think the Monday pile is lighter than it used to be.
Well, this has been a weirdly light couple of weeks.
Yeah. You go from 85 to
Whatever.
22 or whatever this is.
Yeah, like a 1-page
Mm-hmm. Half a
document.
page.
Right, I'm looking at it.
Yeah.
My wife on this
I'm like, whoa.
Yes.
It all fits on one sheet of
It's
paper.
the calm before the storm.
It's the calm before the storm.
Right.
According
It
to,
is.
Mr. Neville.
Next week, ooh.
You remember how busy it was in Zoom one week, and I adjourned half of these cases. It was just adjournment day, like 2 days straight.
So what you're saying is I've got until next week to find a new job.
Yeah.
Yeah. And as an attorney with a P number, doesn't matter what job you get, you're gonna be on the case. And they might even send you notices.
So that's why Bill's here.
That's true. You all are operating out of an office. I was still getting notices on the bench, you know, it's like, substitute counsel,
Yeah.
please,
Well, hopefully,
let me go.
hopefully you don't go too long, you got more control. People are being controlled.
I don't think that negotiation would have happened over Zoom.
You got what was that thing?
What we just had,
Yeah.
that July 30th or whatever, and it seemed like they would have been more contentious if they hadn't seen each other. They warmed up by the time they got out of here.
Yeah, that was very nice.
Mhm. House in their house. Makes a big difference. Mr. Virginia, if you're watching, I need the second page of your conditional dismissal, the signature page.
I'm sure he'll be here later. He's got a busy day.
Oh, he is in here. Right on. Right there, come on. Got a highlighters. Pink highlight.
I don't know who, someone put that up there. I think so.
It's like,
It looks reddish.
yeah, where it oh. Not important, just curious. Good morning. Do you have a matter this morning?
I do,
And what time is your matter scheduled?
9:30,
9:30. Are you Ms. Foster Rudd?
yes,
Yes. All right, so Attorney Snow is representing you?
yes.
Okay. She checked in.
No, I thought.
Did you talk to her yet?
Not this morning.
Okay. She's here and she's looking for the landlord's attorney. talk to her, so. We don't have too heavy of a docket, as you may see. It's the calm before the storm. And Ms. Griffin, we're still waiting on the, plaintiff's attorney as well.
Okay.
How are you doing? Griffin, how are you doing?
I'm hanging in there. They removed the bullet and they removed my leg. So I'm alive. I'm thankful.
Good, the procedure went well. Okay, well, we're waiting around and I'll let you know. When we're
Her and I text this morning.
Oh, yeah, there's 6 landlord-tenant courtrooms, so, the plaintiff's attorney could be on the record in another room, and then once they're done, they come over here. So,
Okay.
if they're ready, they'll be ready, but until then, we just have to, wait a bit.
No problem.
Sign the fact that
It's, I can't go anywhere.
I didn't hear what you said.
I
Oh,
said, no problem. Oh,
fair enough, all right, well, we're glad you're here. How about that?
all righty. Thank you.
You're welcome.
Okay, this is the answer.
Someone else has signed?
Okay. Oh, you signed it.
So, did I?
Yep.
Okay. She took her. Morning, Mr. Dodd.
Good morning, sir.
Team is here. If you all
Oh,
want to just do it at the table, I can mute. Calling case number 2334-6330. This is Sheridan Place 2 versus Kenetta Griffin and all occupants.
Good morning, Your Honor. For the record, my name is Adam KBH 197 on behalf of the plaintiff.
Good morning, Your Honor. Krista McCarl, P number 83515, appearing on behalf of the defendant who appeared via Zoom in the gallery.
And Ms. Griffin, can you state your name for the record?
Kenita Griffin.
Thank you, Ms. Griffin. And Ms. Griffin has appeared by Zoom with permission from the court. So thank you for your patience, Ms. Griffin, this morning.
You're welcome.
Were parties able to work out?
No, Your Honor, unfortunately, we don't have a resolution today, but what we did do is come to an agreement to stipulate to an adjournment, and I'm asking for open discovery and putting in together a scheduling order to go forward with litigation on this one. I filed my answer to appearance and my affirmative defenses, served them on the plaintiff, and then to the court, so I think we're good. We just kind of need a time frame to set up the rules of defense and counsel in court to be able to.
How much time do you need for discovery?
Well, I think I could have it served on plaintiff by the end of the week. I would defer to the plaintiff on how much time they want to respond, witness list and dispositive motion. I was thinking approximately around the 18th of July would be a good time frame to close everything and then schedule it for trial the week after, potentially the first week in August. But again, I defer to the counsel on that.
The 18th of July, that would be this.
I think it was like, give you 30-something days.
That should work out.
Okay. If you all need any adjustments, just let me know. But it is good to set some type of date to keep the ball.
Your Honor, so I can put July 18th for the end of, where we would submit witness lists, dispositive motions would be like the week after, just have time to review. So I would make that for July 20.
July 18th.
July 25th would be for the dispositive motions. Closing discovery would be the 18th of July, and then we would set it, next hearing date for trial would be, we could do the 2nd of August.
Want to do a pre-trial
Yeah, that would be great.
August 2nd? Then we can gear up for either that week or next week or something.
And if you're Honor, could be indulgent, I did submit the order, because unfortunately I'm unable to print it out for the court today, I apologize, but I have to meet the court today.
You can email it. All right, question. Discovery deadline. Do you want the witness list due on July 25th?
Sure. Yeah,
That'll give you some time to review the discovery, and then if some witness pops up in your head for the 25th, you can drop it on that list. That's the only thing I thought about. So July 18th will be the discovery deadline. July 25th will be the dispositive motion deadline and witness list. And then August 2nd, we'll do a pre-trial and see where we're at.
August
2nd. August 2nd, let's see. Hold on, let's check these dates. I think these are all good dates.
And I'm flexible, I don't have to commit to a Tuesday or Friday, I'm like, try and get it on Monday, I'm here.
I think I'm going the week of July 10th.
7th, 8th, 9th.
July 9th, 10th, and 11th, August, okay. Did I put those August dates? I don't think so.
So we're good on the dates?
Fantastic on the dates. Miss Griffin, do you have any questions?
No, Your Honor.
Okay. Well, keep recovering, and there'll be a few dates before you have to come back to court. So there'll be a
Thank you.
discovery deadline where parties will get information from both sides, and then they'll be allowed time to write motions and respond to motions. And after all of that is done, and if we still need to go to trial after that, if parties still need to proceed to trial, then we'll set a trial date. So right now, August 2nd will be your next date that you needed to appear.
Okay. Crystal, she come and see me. She'll let me give me the date.
I'll be able to, meet for that. I can virtually at the August 2nd, she still has, I don't know if she'll be at the hospital that day, I can coordinate later in time with.
Yeah, because,
with,
I mean, or you think you need to be with her?
No, I do not need, I can hear in person, I just.
Oh, okay, permission for her?
Yes.
Yes, she has permission,
Okay, wonderful, no, I'll be here.
absolutely. Ms. Griffin is fine.
It's easy to hear, you may have it. And Your Honor, is it okay if I email the order to Mr. Neville?
Mr. Nevels?
Yeah.
Yes, is it okay if he order?
Sure.
Thank you, sir. Okay. So, the rest of the script? Go ahead. Okay, perfect.
All right. Okay, I'll see you all later.
Wonderful, thank you.
Thank you, Your Honor.
Oh, welcome, Ms.
I'll call
Griffin.
you after court, Ms. Griffin. You can
Okay.
hang out now.
So you're free to leave and
Okay.
happy recovery.
Thank you. If the courts can do something about them little kids with the guns.
Yeah, the court, yes, I agree.
Okay, bye-bye.
There's too many little kids running around with guns. All right, okay. This is Latonia Mason versus Tamara Bolden. Tamara or Tamara?
Tamara.
Tamara, there you go. Tamara Bolden, good morning. I think this. That's what just did, John.
Oh, okay. Oh, yeah, for sure. Yeah.
All right. Calling case number 22394910. This is Latonia Mason versus Tamara Bolden. Appearances, starting with Ms. Mason. Can you state your name?
Latonya Mason.
Thank you.
Good morning, Your Honor. Gerald Featherson, P 83480. On behalf of Ms. Bolden.
Good morning, Ms. Bolden. Can you state your name?
Tamara Bolden.
Thank you. Thank you, Tamara Bolden. All right. So parties were, I'm assuming parties were unable to work out an agreement. Is that correct?
No, Your Honor. At the last hearing, I had appeared for the first time because I had not received the motion. At the last hearing, you stated for Ms. Mason to send me a copy of her ledger, which she did do.
Okay.
And you stated that the court would mail out the motion. I have not received the motion.
Of course.
I sent him a copy of it.
I don't believe she had a copy. I thought the court at the last hearing had all three.
Same day I got it.
Oh, this was the motion, this is a one-line motion saying, need more time for court. I believe that's what your motion said. Your motion.
I believe it was her motion to reinstate, Your Honor, Ms. Mason's motion.
Yeah, it was, this is some good cause, but purposes of judicial economy. Do you have a copy of your motion? I'm sorry. I do remember this case. I'm looking for the.
Well, Judge.
But I don't have the, have it already. Started in November. I remember. Motion to reinstate, defendant shall make prorated payments of $164.51. That was the $23 times the amount of days, I believe. Do not attempt to pay the escrow to the court because second floor will require order. Next court date is June 1st, 2022. Was $164 paid?
Your Honor, I never received notice of the motion. I have no idea what happened at the first hearing.
Or you weren't present when?
I was not present until the last hearing. Someone had to stand in for me. And at that first hearing, I received notice of the reinstatement, even though I never had a chance to reply to it.
Okay. So you said 100 of the 164 was paid?
She paid $167.14.
Okay, so she paid over that 160.
Yes, she
Okay,
did.
all right. I just, okay. All right. Where are we at now? We're here, it's the date and time set. This case has been going on since November. How much money is owed? What are the arguments? why she's not paying? What are we doing?
I mean, again, Your Honor, I haven't had a chance to review the motion. I would argue against the grounds for reinstating if defense counsel never received a copy. I believe there's deficiencies with the reinstatement for that reason.
Your Honor, Mrs. Bolden hasn't paid me any money out of her pocket since 2021. They paid her rent up from 2021, Amisha, to October 2022. June 2024.
So you're asking for, another date to reply to the motion?
I'm asking for dismissal today, Your Honor, but if I do not receive my dismissal, then yes, Your Honor, I need another day to at least look at this motion.
Do you have a motion on you? I don't have it on you.
That was what I received that same day.
Wow. I'm not like directing that towards you. Where is the file? That one. No, the motion is in the file. That was the motion, that was the order for the motion, but in this case, it would have been easier to just refile.
At this point, Your Honor, for due process, I think it should be refiled.
Your Honor, this case has been going on so long, and I have not been receiving anything from this person. Unless you sign for her to pay.
All right, can we make a copy of this, get this to Mr. President? And I'll allow you to review the motion, argue your case. We'll be done, we'll have a resolution today. If it gets dismissed, then you can refile it. If not, it was already dismissed. Probably would have been done if you just refiled it.
Well, Your Honor, it was in my heart, Saturday on the desk or something, and it never got to you.
The problem was that you missed the court date. That's the real issue. They got
Just one
dismissed.
court date, I had an emergency, so I missed one court date, but I was there on the president, all the rest.
And the case got adjourned from December to March. It should never happen. 3 months. 3-month adjournment. That shouldn't happen. That's the real thing. And it's set for a month, from March 28th to June 1st, to May 1st.
Hey, I called down a couple of times, just told me that they were waiting for ticket due or something like that.
I understand what you're trying to do, 100%. I think procedurally, it's worked out in the worst case scenario. So I'll allow you time to,
Can we adjourn this case, Your Honor?
if you're requesting a dismissal, if you're adjourning this, you don't need an adjournment.
I was asking like for a quick recess, like.
Oh, yeah, yeah. I'll recall it today, though.
Yep, I'll be back soon.
2394910. This is Tonya Mason versus Aaron Bolden. All occupants. Tamara Bolden. All right, can I have your name for the record?
Latanya Mason.
Gerald Featherston, P83480, on behalf of Ms. Bolden.
Camera.
All right, this matter has gone on for a very long time. We just recessed the matter because you did not receive the motion. You notified the court you didn't receive the motion today, so we provided the motion for you to, Ms. Mason had a copy provided to you to review. We're able to review it. Now we're back.
All right, Your Honor, so I did review it. I'm not gonna argue against someone's mother's being sick and them having to see her. I still think we do have this due process issue. I tried to make a fair settlement. We weren't able to settle the case, so at this time, because I was not served any copy of the motion before this case was being stated, I am still asking for dismissal.
All right. Why shouldn't this case be dismissed? Are you in favor of dismissal?
No. This case has been going on and on, Your Honor.
Why shouldn't this case be dismissed?
Because it shouldn't be dismissed, you know, this has been going on too long. I've been going back and forth, I've been down here, I missed one time because of my mother. I'm sorry she got ill that day and I didn't make it to court. But I don't feel it's fair that she gets more time in my property. She's been there since 2021. I mean, she's been there since 2018, I'm sorry. But she hasn't paid since 2021, and it's 2023, Your Honor. And the only thing she paid was the 167.14 that you.
That I ordered, had to order.
Pay.
Okay. Right. And have you paid June's rent?
No.
Why? And why not?
I can pay it.
Why haven't you paid it though?
I was waiting till we came to court.
Okay, but we've been going to court since November of 2022.
So this could have been solved a long time ago. I sent Ms. Mason messages to pay her. This was in October and November before we even went to court in December. For the first time in December, when the judge asked me, did I have the money? I told her, yeah. In return, Ms. Mason said she didn't want it because she filed for an eviction.
There's a non-payment of rent though, so the only way.
So this is the thing. Sarah paid her for that amount of time. Once
What
that
amount
was
of time?
from, I believe it was July to September, from July to October. In return, I asked her, what did Section 8 give her? What did they pay towards my rent so that I could give her the difference? No response. That was 2 months in a row. When she finally responded to me, it was telling me that I owed her $3,000 in a 2 month time span.
How much is your
The
monthly?
judge in December told her, you pulling a number out the sky. So we could have been,
Your Honor, I had been on this case before it had initially been dismissed. There were some issues with the ledger. Ms. Mason was paying or charging upwards of $175 for late fees. There was also discrepancies between what both parties believed should have been paid through Sarah, and we were getting, not Sarah, excuse me, through Misha, through the subsidy. And we're getting to a point where I thought we were gonna be in agreement on what was owed, and then the case was dismissed.
Your Honor, and the judge told me that I couldn't raise the rent because, the last lease that we had was for $850. I said, okay, I can't raise the rent why she's not, I didn't want to sign another lease. If you're not paying, I didn't want to sign another lease. So the judge told me I went about that wrong. I cannot raise her rent. I have to charge her what the lease originally stated. So then I went back, changed my numbers, and then we went back to court, and I had the correct numbers. Also, Mission did pay her up, but then they took a percentage out because they wanted the home to get inspected.
20%?
Yes,
Okay.
they took the 20% out. Okay, Mrs. Bowden got the check. The house did not need to be inspected
Did you retain the 20% check from
I just
Mr.?
received it a week ago.
Did you give it to the landlord?
Not yet.
Why not?
I just hadn't get, I was supposed to come to court. I'll give it to her.
Okay.
It's not a problem.
And what is the amount of that check?
It's $1,800.
Your Honor, I would also agree that she's entitled to the 20% if she didn't get her inspections done at the time of fashion.
Who's entitled to the 20%?
Never got an inspection
I
done.
Who's
mean,
entitled to the
she-
20%?
I would say she's entitled to.
Why would she be entitled to the money that she's supposed to get for not paying the rent?
I'm not saying, sorry, Your
I'm
Honor.
sorry.
I'm not saying the plaintiff isn't entitled to some rental money, but I'm saying according to the contract that was previously signed, she agreed that 20% would be waived and it would go to the defendant if she did not get the necessary certificate of compliance.
And how long does it take are there any delays with the city or, are they able to inspect it within that same timetable?
So in these conditional dismissals, we usually have language stating that they give us affidavits that it's basically the city's fault that they can't get the COC. Instead of their fault, we will give them extensions.
So how is she entitled to this money? That's what I'm trying to figure out.
There was a simple contract that said if she did not get the certificate of compliance in time, she forfeited the 20% and the defendant got the 20%.
Your
That's
Honor,
pretty standard for all SARA agreements that have the 80-20 split.
I just don't like this because
Your Honor, Section 8 inspects my property. So I thought it was aware that when they sent me the paperwork for the 20%, that it would get waived because my property did get inspected because she's on Section 8. So they have to inspect my property once a year or twice a year. So she had already just had an inspection on the property from Section 8.
and the money is to go. All right. So this is the issue. This is the main issue right now.
But she still hasn't paid me since June 17th, 2021.
That's
Your
They
Honor,
paid her up until October 22. She hasn't paid me anything but the $167.14 that you ordered her to pay me after October 2022.
Your Honor, I think you see that there are procedural issues here. I have made an offer to settle this case.
Now, I thought the
They were
Sarah
unwilling.
said,
So again, because of the procedural issues, we are asking for assistance.
Sarah says, Section 8 inspection. And he used that as well. I thought that was either or.
did Sarah ever say that?
What was that, Your Honor?
Section 8, they inspect their Section 8 inspection.
So yes,
As an inspection.
yes, that is true,
So
but
how is this even an issue if you know she has Section 8? Like, I just don't like the fact that she's not able to get any money. Your case is like, this is the issue. And we can't even get to the merits of it anyway. The case was filed November 14th, 2022 for non-payment of rent. Case was adjourned December 8th for 3 months. 3 entire months, 93 days, 92, 91, 93 days. Then it gets rescheduled from the 3rd back to February 13th. To, I believe, my court. I get it on the 13th. We schedule it for March 14th, a month later. That's another month delay. No rent is being paid, nobody's, are you paying property taxes? No, I didn't think so. So nothing was being paid since then. All right, now we move forward. You failed to appear, your mother was sick. You missed the case.
It's on 14. Remember? This was lost.
Oh,
Somebody left their phone, Judge.
are they trying to find it?
Yeah.
It's in the side button.
They
I
left
gave
their
it to him.
Just hit the side button. Side. Okay. Then I ordered a hearing. Motion to set aside dismissal, was granted. However, I didn't allow Mr. Featherston to argue the motion, so we had to set a date to come back. When we set that date, I at least ordered the prorated amount to be paid for the month of May. And was it for further months?
Was here, Your Honor.
You weren't here. All right, and then today, Mr. Featherston, you made the court aware on the date of the trial that you didn't receive the motion from the court or either side. The one sentence, motion. You're requesting this is dismissed because, for what reason?
The case was reinstated without defense counsel being notified or given a chance to respond to the motion.
I thought that's what we were here today, to give you the opportunity to argue.
I mean, I still think my procedural issue was preserved from the last hearing. I
think
still
so.
wanted to view the motion.
This is the thing. You got a bad deal.
Sure.
You got a raw deal from us, really.
Sure.
There are multiple ways this could have prevented a little bit of a delay, because that motion could have been denied rather than sitting on this table. It wasn't intentional, but in hindsight, obviously, if you weren't going to grant this motion, you could have known that probably end of March or the order for rehearing was set in May. So we didn't do you any favors in that case. This case was adjourned from December to the 3rd. Wasn't a judge in December, but it came to me on the 3rd. The court bumped it up, confused everybody, so I was granting everybody motion dates. Like everyone who filed, I would grant a motion date. There's been a challenge because an attorney challenging the reinstatement, and procedurally, he's correct. Technically, the motion didn't have good cause, so I have to deny this motion. Now, that will dismiss the case, and you'll have to refile. Now, you're not doing any favors for any, yeah. I have to dismiss the case, and you have to refile the case. Now,
Can she at least move? Can she at least get out of my house? Can I have my house back at least?
you have to have an order from the court to do that. Should she? That's another question. Should she be paying rent? That's another question. But can I order it right now? No, because I have to set aside. I have to deny the motion that you filed and dismiss the matter.
Why I did everything I was supposed to do? Why am I doing?
Well, you failed to appear, and because you failed to appear, you filed a motion to reinstate. Counsel is challenging your motion to reinstate. He didn't have an opportunity to argue the motion to reinstate before I reinstated the case, which would deem this,
You just gave him time though. It's only one sentence.
what do you mean?
You just gave him the paper to.
Right. But what I'm saying is, I gave him time to review, but I also reinstated this. But I set aside the reinstatement, so this hearing today is really to determine whether this case is gonna be reinstated or this case will be dismissed and has to be refiled. And based on his representations, I have to dismiss this case. That's what I'm saying. We didn't do you any favors. I probably could have saved you a month if my case volume wasn't so high, but I can't.
So I guess.
I can't defeat it.
It's court messed up.
I'm not taking full responsibility.
I mean, my mom got sick. I know things happen.
But your
okay?
case, right, I'm telling you, I'm being honest with you. okay? The case is gonna be dismissed regardless. I'm just telling you why it's dismissed. Telling you why it's dismissed, because you filed a motion that didn't have good cause. I should have denied it initially, but I granted a hearing, as I did everyone else. He challenged it, case is dismissed. Now, the 3-month delay, I didn't have anything to do with that. Case should have been done in 3 months, in my opinion. She should have paid rent in the meantime, in my opinion. She's got 1,800 right now. I have to dismiss this case. And because I have to dismiss, I can't order her to do anything. What she should do, that's different. But I can't order it, and I apologize for the inconvenience. But I have to dismiss this case, or it's just gonna go on. He's gonna challenge it, file another motion to dismiss it, and gonna lose another month. Or another 2 weeks. I have to show up in person to argue that.
I show up anyway at this point.
But he has to show up there. So this matter, right now, this matter is dismissed. And Ms. Mason just refiled.
Thank you, Your Honor.
You're welcome.
Yeah. Please do.
Should have phone from the bathroom.
Mm-hmm.
I call right now.
Oh, shoot.
I think it's Caroline calling phone. It's your phone.
Thank you.
She's not here, but I can email her. I'll walk around and try to find it. I'll send her an email message report.
Oh, okay, thank you.
Those watching by Zoom, matter is concluded. This was Venus Calloway versus Ernest Brown. This was adjourned due to an issue with the chain of title, but that issue is resolved. That was cured. Mr. Brown failed to appear, but Mr. Christensen was here to represent him. A default judgment was issued with the move-out date of June 30th, 2023. Couldn't be in all occupants. There are multiple occupants in the property, so this is in the name party of Ernest Brown. Parties will receive their judgments today. That concludes this docket.